Can you hear me now? Let me know if you can hear me now. I don't know why my microphone's not working. But as I was saying, most of these documents I can't even look at because they're restricted and I don't have permission to see them. Uh, Turn my volume up. There. Let's see. Like the document 330, it's just all Netflix asking them to restrict documents like stuff from trial transcripts, and they're doing that because Netflix or Mr. Colborn's attorneys can turn around and give that information to Miss Schuler, who then can put it in the convicting documentary. One of the documents I read, they actually state that she sent in an email that they should have recorded this stuff because they could have used it in a documentary. But brief in opposition filed by all plaintiffs, motion for summary judgment. So let's see if Hillary looks at this one. Oh, here we go. 78 pages. This is going to be fun. Introduction. Plaintiff respectfully submits. Make this a little bigger. Plaintiffs respectfully submits to combined memorandum in opposition to defendant's summary judgment motions. As explained below, there are material disputes of fact for trial on plaintiff's claims for defamation and intentional infliction of emotional distress that are not overcome by any of the defendant's arguments, procedural posture, and material facts. The case arises out of Netflix series Making a Murder. Defendants Crow Media and principals Laura Riccardi and Maura Demos take significant credit for the content of MAM, contending that they are producers of the series. However, Netflix was also undeniably heavily involved in the creative development of each and every episode as described further below. Netflix approved the final cuts of all MAM episodes, Colborn additional proposed finding of fact, hereafter capped. From this first involvement, Netflix aimed to craft the series from a marketing perspective and also from an award qualifying perspective. See, this is just redacted too. So, tell the story of Stephen Avery, a former resident of Manitowoc County, Wisconsin, who was convicted in 2007 of killing a young woman named Teresa Halbach. While the parties dispute the extent of which the series conveys to viewers that Avery was wrongly convicted for the crime, there is no dispute that the series also highlights Avery's conviction for a prior alleged rape for which he served time in prison, but for which he was later exonerated on the basis of DNA evidence. Don't know what the fuck this is supposed to say, but the document I read that was restricted is basically everything they asked to be restricted out of this. So Chrome was also involved in efforts to brainstorm Avery's defense attorneys to attempt to obtain additional testing of evidence presented in his defense. News that Netflix embraced. Netflix likewise started from the point of view of Avery was innocent of Halbach's murder and that the judge was biased against him. Our in-depth examination of the structure of MAM was critical to understanding its presentation of the plaintiff, Andrew Colborn, as a participant in an alleged Sheriff's Department conspiracy to frame Stephen Avery for Teresa Halbach's murder. Well, it is clearly he was framed the first time. 18 alibi witnesses, a receipt stating he was nowhere near where the assault took place, and they still convicted him. In particular, Netflix sought to argue with the series' reliance on voiceovers by Avery himself to tell Avery's narrative. Baker DeSalle, the final product of MAM, according to Netflix's creative team, was provided as an immersive, all-encompassing experience for the viewer, including deft and unexpected foreshadowing of key elements, pitch-perfect callbacks of evidence, and breathtaking reveals, accompanied by thriller, atmosphere, and imparted through the music score. The series unfolds over... I'm not going to read this because this is just going over what each episode... We've all seen Making a Murder, right? Well, I just paid... might as well download this. Paying for it. So that was that one. Most restricted document by all plaintiffs. That's the one I just read. Exhibits 3 to 21, Declaration and Megafin. This is just everything that they asked to be redacted. Like, that's why I didn't read most of these, because it's really no info. Let's see if they're gonna let us. Okay. Exhibit 1, 6 pages. Download. Save. Alright. Dear Ms. Summers, I write in response to your letter dated July 15, 2022 regarding alleged deficiencies in response to Laura Riccardi, Moira Demos, and Crow Media, collectively the producer defendants, to rescind requests of production from plaintiff. Before turning to the substance of your letter, I must first address the untimeliness of plaintiff's complaints regarding any alleged deficiencies. The producer defendant's responses at issue in your letter date from mid-July 2021, more than 1 year ago, though early April 2022, many months ago. Besides the passage of time, the deadline for the fact discovery in this case came and went in April 8th, 2022. Indeed, even the deadline for depositions for all deponents except plaintiff was May 20th, 2022. Nearly 2 months before you sent your letter. Moreover, the parties met and conferred regarding respective alleged discovery deficiencies months ago in April and early May 2022, following correspondence sent by various defendants in March 2022. Then we heard nothing on the subject from plaintiff until July 15, 2022. This time for raising complaints about parties' response to the written discovery has long since passed. Indeed, the deadline for the expert disclosure is less than a month away for that. Summary judgment motions is less than 6 weeks. It's unfair to expect the producer defendants that their counsel divert their time and attention from such matters to address issues related to the fact discovery at the belated juncture. We have strived in a reasonable combination with respect to discovery deadlines where there was good reason. For example, we agreed to let the plaintiffs depose Lisa Dennis and Mary Manhart after May 20th, 2022 deadline, when those deponents had health issues and precluded earlier depositions. And we did not attempt to seize some litigation advantage based on the fact that plaintiff had waited to notice their depositions until the final week for depositions. However, there is no similar good cause for plaintiff waiting until mid-July 2022 to raise complaints about perceived deficiencies in producer defendants' responses to written discovery, some of which have back more than 1 year. Particularly true considering the enormous burden the plaintiff written discovery request placed on the producer defendants in the action, as reflected in your letter. The plaintiff served 7 sets of requests for documents and producer defendants, including a final 7th set that was very broad and required the producer defendants to effectively redo prior searches and even review documents in response thereto. In contrast to the normal producer in discovery, where parties begin with more general requests and then send more targeted and narrow follow-up requests later. In response to plaintiff's 7 sets of requests, production and producer defendants have produced nearly 35,000 pages of documents. Producer defendants has also produced approximately 15 hours, 20 minutes of new raw footage, plaintiff testimony at the average criminal trial in response to plaintiff's request for such raw footage. Producer defendants did so after the parties entered into agreement whereby the producer defendants agreed to search for, process, and produce the inusable form to the plaintiff, all in the raw footage that they had of the plaintiff testifying at the trial. In return, plaintiff withdrawing his own other requests for footage. Even that compromising agreement was an enormous undertaking, which required Ms. Riccardi and Ms. Demos to put aside respective professional projects and spend many dozens of hours each. Indeed, in total, Ms. Riccardi has personally spent more than 150 hours, and Ms. Demos has personally spent approximately 100 hours in connection with responding to plaintiff's 7 set of requests for production. This is in addition to many, many hundreds of hours that the attorneys have spent performing various tasks related to responding to plaintiff sets of document requests, including reviewing and processing the many thousands of responsive documents and the 34,942 pages of responsive materials that the producer defendants produced to plaintiff in the action. In sum, the burden for the producer defendants have borne in this case, responding to the plaintiff's request for production, have been extraordinary, greatly exceeding the propriety of the limitations in Federal Rule Civil Procedure Rule 26. Yet the producer defendants have borne the burden, along with the burdens associated with the plaintiff's desire to take full slate of depositions in the case and issue extraordinarily broad document subpoenas to many parties, including individuals who formerly worked with Crow Media, but required the producer defendants and their counsel to devote many additional hours performing privileged review of tens of thousands of pages of documents produced by those individuals. According to the producer defendants, believe that any complaints that the plaintiff had about the response to the plaintiff's various set of requests to production are not just without merit, but untimely and at the point undue when viewed in the context of the discovery process to date. That said, I will respond below to the substance of your letter to further demonstrate the good faith approach the producer defendants have taken throughout the case responding to plaintiff's request for production, in the hopes of putting these matters to rest so that the parties can proceed with those aspects in the case remain to be completed. Request number 1. The Netflix already produced copies of the final executed license agreements in response to the identical request for production of the same material the plaintiff served on Netflix. Producer defendants did not have any additional documents besides those already produced by Netflix. Request number 2. All responsive documents within the scope of the producer defendants agreed to produce have been produced from plaintiff by the producer defendants on May 9, 2022. Producer defendants are not withholding additional documents beyond those that they have previously logged. Producer defendants have produced documents as they were kept in the ordinary course of business, and thus the plaintiff did himself. They were not required to produce them with the labeling that correspond to specific categories to plaintiff's request. Finally, the parties, once again, including plaintiff, did not agree to exchange lists of search terms in the case of part of their ESI protocol, and they have not done so. Without going into detail, I can tell you that we did not merely search for Mr. Colborn's name, but included a host of potential misspellings and variations, including the production documents that did not mention Colborn by name, but the reference law enforcement more, generally the response to portions of Making Murder that we put as an issue by the Second Amendment complaint. And erring the side of over-inclusion, we ultimately produced copies of Season 1 notes and individuals that Netflix provided producer defendants, even where such notes made no reference to Mr. Colborn or concerned portions of Making a Murder that may not put a issue by Second Amendment complaint. Plaintiff's fifth set of requests for production. We have provided plaintiff copies of all documents that we received for all parties to whom is issued document subpoenas in the case, including documents served from the Manitowoc County Sheriff's Office, the Calumet County Sheriff's Office, and the Wisconsin DOJ. To the extent, if any, there are documents therein responsive to plaintiff's fifth set of requests, all such documents would be contained in those productions. Plaintiff's sixth set of requests for production. Request number 3. Producer defendants produced all documents they agreed to produce and then some. And producer defendants produced the notes that they received from Netflix personnel regarding Season 1 of Making a Murder, not just those described by Ms. Demos at 53 minutes into the reference video, but plaintiff's third set of requests, requests number 2 and 3. The producer defendants have not withheld any additional documents beyond those reflected in privilege logs they previously served on plaintiffs in early May 2022. Request number 4. Producer defendants are not withholding rough cuts or sketches pursuant to objections and privileges. As explained in producer defendants' response to request number 4, production defendants do not have any documents responsive to the request. A diligent search or reasonable inquiry have been made to comply with the request. However, the producer defendants did not achieve or otherwise retain and not possess any rough cut sketches or prior versions of episodes of Making a Murder, only have final versions of episodes. Request number 5 and number 6. As request number 3, producer defendants, which materials agreed to produce, producer defendants have withheld any additional documents beyond those reflected in privilege logs previously served on plaintiff on May 9th, 2022. Also, third set of requests 2 and 3, with respect to the FRCP and the ESA protocols in case producer defendants' obligations, searches, and productions with respect to materials exchanged by the producer defendants and Netflix personal. Plaintiff's 7th set of requests for production. Request number 1 and 2, producer defendants produce all materials that they agreed to produce in the search and production documents, including Colborn and links, names, along with misspellings of same, along with other materials. Producer defendants have not withheld any additional documents beyond the reflected privilege allowed previously served on plaintiff's May 9th, 2022. Request number 2 and 3, with respect to the FRCP, ESI protocol, in the case producer defendants searches production obligations. Request number 3, the request remains vague and ambiguous, notwithstanding your letter's citation and definition of the word antagonist, along with the other matters. Nonetheless, to avoid unnecessary disputes, we ran a search for the name antiguous in response to your letter and did not find any documents containing the term that related to either plaintiff or those portions of making a murder place in the issue by the second amended complaint. Request number 4 and 5, producer defendants produce all documents they agreed to produce. Producer defendants have withheld additional documents beyond those reflected in the privilege logs they previously served on the plaintiff on May 9th, 2022. Request number 6, 7, 8, and 9, they are agreed to produce. It's just the same wording over and over. So basically, they're telling them that they turned everything over. So that was that document. These are all just like Rolling Stone articles. Now, why isn't he choosing to sue any of these other entities that carried on the same story that Netflix did? Alright, so we'll go to the first one filed today. Reply brief from support filed by Netflix Incorporated in motion for summary judgment. I don't know if they're gonna yeah, I get to see this one. All the other ones were restricted, so. Plaintiff Colborn opposition to defendant's motion for summary judgment. So yeah, both sides have asked for a summary judgment. Shows that after years of litigation and months of discovery, he can point to no evidence that would allow him to meet his fundamental burdens of proof. As a public official suing over a documentary about issues of public concern, Colborn must prove the challenged statements in Making a Murder, all material false. He must prove by clear and convincing evidence that Netflix published those statements with actual malice. To the extent that these claims arise from alleged implications, Colborn must prove again by clear and convincing evidence that Netflix intended for reasonable viewers to understand MAM to convey the alleged defamatory implications, or knew that they would. Further, as the respondent to the motion of summary judgment, Colborn must present affirmative evidence that would allow a reasonable jury, applying proper evidentiary standards, to find in his favor. Colborn's opposition does none of this. Instead, he indulges in extent mischaracterization of both the parties' communications during MAM development and MAM's content itself. Relying on improper amendment in response to Netflix's statement of proposal materials, he then fixates on messages from a handful of anonymous individuals, theorizing that the deranged Cranko somehow represented the 19.3 million people who are... Let me read that again. He then fixates on the messages from a handful of anonymous individuals, theorizing that the deranged cranks somehow represent the 19.3 million people who, according to Colborn, watched MAM within weeks of its release. He then proceeds to misstate both his burdens of proof in the applicable law. By the end of this opposition, this must be clear, despite the exceptional and extensive email record Colborn relies upon, he has not shred He has not a shred of evidence that Netflix published any statement about him with knowledge of his falsity or serious doubts as to the truth. Nor could it, given it did not have access to raw footage or any other source material. Thus, the court does not need to watch MAM. Indeed, it could assume MAM at false. To conclude that the no reasonable jury could find actual malice by clear and convincing evidence and determine the Colborn's claims against Netflix must be dismissed for this reason alone. In the court does If the court does decide to watch MAM and independently evaluate how the series as a whole documents Stephen Avery's claims that the law enforcement framed him for murder, it will find Colborn's evidence on material falsity equally deficient. MAM does not adopt Avery's claims as truth. It merely presents them as accusations alongside rebuttals by Avery's dictators. None of the MAM necessary edits to testimony change against of what actually said in open court. None of the 52 statements Colborn listed in his cross motion incorporate in the opposition in reference to false, despite hyped up heading. Colborn does not identify even one flat-out accusation of framing, and his claims about graphics and are meritless. In sum, Colborn's opposition provides no sufficient reason for the case to go to trial, and plenty of response to grant Netflix summary judgment and litigation for good. No reasonable jury could find actual malice by clear and convincing evidence. Actual malice means the defendant had a high degree of awareness of probable falsity and entertained serious doubts. Now, he claims he's never watched the whole documentary. And from what I've been hearing, Brenda Schuler is the one that pretty much convinced him to take his lawsuit, and the first lawyers he went to wouldn't take his case. And somehow Michael Griesbach jumped on board, but Michael Griesbach made an agreement before he took his case that he could back out at any time, and that's exactly what he did. But no reasonable jury can find actual malice by clear and convincing evidence. Netflix demonstrated in an opening memorandum that it must prevail on the issue of actual malice because neither in notes or filmmakers nor any other evidence support a contrary finding. Colborn must present facts, not more mere allegations, inferences, or argument that would allow a reasonable jury to find by clear and convincing evidence that Netflix distributed MAM with the actual malice. Colborn devotes only 5 pages of his 78-page brief to the dispositive issue and only 4 paragraphs to Netflix. Even though his state of mind must be determined separately from that of the producer defendants, the lack of attention glaring, not surprising, Colborn just does not have much to say. First and foremost, Colborn points to the evidence that he could use generally dispute most of the important material facts underlying the actual malice. Question: no one at Netflix attended Avery's legal proceedings or even viewed or possessed unedited footage or any other source of material before it was assembled into episodes by filmmakers. No one at Netflix compared one cut to another identity or monitored the filmmakers. Immeasurably granular edits as they tried to condense events that spanned 2 decades and include a 5-week murder trial into a 10-hour series. Colborn cannot explain how, given the unconverted evidence, anyone at the Netflix had any relevant knowledge about what the filmmakers decided to include or omit, much less knowledge of their decision somehow rendered statements at MAM that are of and concerning him materially false. Instead of evidence, Colborn relies on speculation and scapegoating. He insists that because Netflix represents visited the filmmaker's editing studio, jurors may infer that Netflix reviewed raw footage and other source materials to the visit. But a non-moving party on the summary judgment is entitled only to reasonable inferences from the undisputed facts. to draw inferences and be supported by only speculation of conjecture. The state of Beers, blah 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 blah. One visit on the editing studio did not support inference that Netflix employees viewed any raw footage during the visit, much less raw footage that underlies any of the edits that concern Colborn. He also complains about purportedly missing documents, including episode cuts, and procedurally this is improper. Colborn never brought a motion to compel on the subject. His discovery disputes may not be raised, and the first time after discovery closes in opposition to summary judgment. Even if I were proper to complain now, Colborn does not do so with it specifically required by Rule 56. Instead, he concedes that the documents he purports to need to be not exist, yet demands trial anyway, implying that the missing cut. Yeah, Colborn wants this to go to trial. Netflix asked for a summary judgment first, and then Colborn's team did the same thing too. So it's just back and forth, back and forth, back and forth. Them trying to seal and unseal and restrict and unrestrict. So waste of time, in my opinion. I wonder what his bill's going to be if he loses. Bottom line, unlike the journalist whose article was an issue, and not only Griesbach dropped out, but the other attorney too did too. So they're probably the smart ones. Whether any of the edit amounted to actual falsification, the result of Netflix could not have published any statements that Colborn challenged with actual malice. Colborn's other arguments on actual malice lack merit. Colborn also argues that Netflix shaped MAM to fit a preconceived storyline, casting him as a villain. And James Link was then looked at as a villain too. Why isn't he also suing Netflix? Maybe Colborn's just a patsy. I mean, I don't know. Colborn claimed, I'm just going to read this. Colborn claims that Netflix pushed Chrome to do whatever it took to hammer home the message that law enforcement officers were out to get Avery and to frame him for Miss Teresa Halbach's murder. The argument, not evidence, and misleading that the Colborn claims, for example, defendants refer to Colborn as one of the baddies and the villains of the series. The reference to baddies was about other named individuals, not Colborn. The sole Netflix reference to a key villain that Colborn cites is Dennis Vogel. I agree. And Tom Kasurek, the prosecution responsible for Avery's wrongful rape conviction. Yep. Next, Colborn accuses Netflix of watching the documentary that would have the audience feeling fury and shouting at their screens throughout, but even construing that the evidence in the manner most favorable to Colborn, the Fury Note, which relates to the verdict scene, as most supports an inference that the author believed that Avery's conviction to be somehow unjust and wanted viewers upset about the injustice. Publication and content the publisher believes to be true, opposition to actual malice. Separate note, the shouting, meanwhile, refers to the entire arc of MAM and the strong reactions, positive, negative, the viewers would have toward all the subjects. None of the notes Colborn cites mentions him or suggests falsification as a way to stir viewers' emotions. Also, Colborn is wrong that the balanced report could not incite such strong emotions. A balanced report about Avery's wrongful rape conviction certainly could incite some strong emotions. For example, Colborn also mischaracterized the note that he contends the show's Netflix celebrated when the edited version of episode 5 was changed so that Mr. Colborn looked caught in a clear lie. That's not what the note says. It's not suggested that the footage was falsified. The word look is to there. Rather, the statement reflects the writer's opinions that the trial footage shows that Colborn goes from being so sure that it's caught in a clear lie about the origin of the car, make, and model. The extent this comment shows subject awareness, anything material. It shows that the writer believed that the Colborn had been caught lying, not that he thought the scene was false. Further, there is no evidence that the referenced scene actually appears in the final version of MAM. Colborn also invents the Netflix celebrated the changes to the set Mr. Colborn up to be the potential cop to plant the car in episode 5, and falsely asserts that Netflix described Chrome's edits to identify Mr. Colborn as responsible for planting Miss Hallbach's vehicle on Avery's property. Saying Colborn is a potential cop to plant the car does not assume Colborn actually planted anything, nor does it express knowledge of the truth or falsity of the claim. It merely reflects the undisputed fact that Avery's defense alleged Colborn may have planted Hallbach's SUV. Colborn stacks speculation on top of mischaracterization when he says that. From these comments, it can be inferred that Netflix was involved during the evolution of Mr. Colborn's testimony into a segment portrayed him in a significantly worse light. That is not reasonable inference. The rest of the false premise is wholly unsupported by the evidence in the record, thus cannot help. Colborn met his burden of proof, whereas the record taken as a whole cannot lead a rational tier of a fact to find for a non-moving party. There is no genuine issue for trial. Colborn next refers emails between Netflix employees discussing comments by Avery defense lawyer Jerry Buting, and they were concerned could be interpreted as alleging the law enforcement themselves killed Hallbach. No, I believe that Mr. Kratz is the one in his closing statements says, so what if the key was planted? You really think your cops killed this lady? So I don't know. Sorry if somebody's messaging me. But Colborn next refers to emails between Netflix employees, but these documents do not appear in the final version of MAM, are not an issue. Colborn nowhere claims MAM accuses him of participating in Hallbach's killing, and any knowledge of the falsity of statements that are not even MAM irrelevant. Moreover, the fact the statement about Netflix employees expressed doubts did not appear in MAM undercuts any inference Netflix is suspected. Finally, Colborn contends that Netflix also looked for every opportunity to emphasize shock at Mr. Colborn's appearance in the series, even when he is shown performing such routine tasks as escorting Avery or Dassey to the forum or the courtroom. Even if this were accurate, it is not. Expressing shock at the undisputed fact that Colborn escorted Avery and his co-defendant in court is an opinion, not an admission of doubt about truth. For all the reasons Colborn has offered, no evidence to support hammer-down claim, but even if the documents he cites and mischaracterizes support his contention, the Netflix had a preconceived storyline having one in evidence of actual malice, only if there is evidence the storyline was knowingly false. The content of the MAM itself is not evidence of actual malice. Colborn's second argument regarding actual malice has even less support. His first cites a number of cases, nearly all of them outside of Wisconsin and the Seventh Circuit, and he claims stand for the prosecution of the technique. See, yeah, because this is now in the federal court. Yeah. His lawyers aren't really smart. I mean, just I don't know how many of you guys watching heard when Michael Griesbach put his foot in his mouth in front of Ludwig and got chewed his ass out, and then was forced to produce documents that Netflix was inquiring about, and then he said, yeah, I don't want to be your counsel no more, Colborn. I'm out of here. And Colborn agreed that he could go. Also in section, Colborn claims that MAM use of graphics, commentary, sound effects, and visual imagery instituted, implied, and used innuendo to convey that he did in fact plan the evidence as they, Avery defense alleged, presented this testimony in a way that made it seem less credible. Colborn says that this evidence of actual malice, it is not all part of Colborn's gross mischaracterization of MAM's content, and the fact that he does not allege any of these aspects are false. Whether MAM was false and whether Netflix knew it was false are different questions. False, like, they got a good point there. Like, Jerry Buting and Dean Strang tried bringing home tried to get the jury to look at consider that the fact that the cops may have framed him. The producer defendants were just documenting what happened. So, yeah. Colborn does not point to a shred of evidence to support his insinuations that Netflix could have been found responsible for purposeful avoidance of truth. Meaning through illustration, a quote, and a pattern of biased, incorrect reporting, similar to the defendants in case he cites. That is because there is none. To the contrary, such claims are contradicted by the fact that MAM included a significant amount of materials favorable to law enforcement and Colborn. Although the plaintiff may prove actual malice using circumstantial evidence, Colborn ignores the Seventh Circuit's caution that courts must be careful not to place too much reliance on such factors. Here, Colborn's circumstantial evidence is not evidence at all. It consists entirely of counsel's mischaracterization of the content of MAM. Colborn ignores his burden regarding allegedly defamatory implications. Finally, despite not pleading to the libeled by implication claim, Colborn now attempts to survive summary judgment by claiming that MAM insinuated, implied, and used innuendo to convey that Colborn did in fact plant the evidence, as the defense alleged. See also, MAM implies no such thing. I documented Avery's accusations and rebuttals to those accusations, but neither adopted nor endorsed them. Regardless, the actual malice inquiry is twofold, where the claim is based on the implication of the innuendo. Colborn must still show actual malice as to falsity, and that Netflix knew or had high degree of awareness that the challenge statements' implications were probably false. In addition, he must show actual malice as to meaning. The Netflix intended for reasonable viewers to understand MAM to convey the defamatory implication Colborn alleges. Colborn's opposition does not contain single reference. He simply ignores that this seminal binding case, and as a result has forfeited any rebuttal to Netflix's argument that the unconverted declarations that Netflix has no such knowledge or intent. Netflix, therefore, is entitled to summary judgment on all of Colborn's claims to the extent they premised on what MAM purportedly implies. In sum, Colborn has failed to identify any evidence sufficient to create a genuine dispute of any material fact that would allow a reasonable jury to clearly, convincingly find actual malice or acknowledge intent regarding allegedly defamatory implications. According, this court should grant summary judgment in Netflix's favor in these dispositive issues. Where was I? Colborn cannot show any portion of MAM about him and materially false. The opposition also utterly fails to meet Colborn's burden to demonstrate a jury issue on the question of material falsity. Colborn pretends that defendants have the burden to prove the defense of substantial truth. He is wrong. Colborn bears the burden to prove material falsity, and that determination that the statements at issue are substantially true is simply another way of saying that Colborn cannot meet his burden. Plaintiff could not meet their burden and falsity because the record shows that the allegedly defamatory implication was substantially true. To access this element, the court must first know the universe of challenge statements that has been a moving target even now. Colborn purports to put in issue statements he did not even plead as accountable. These statements must be discarded. What's left are statements that fall generally into these buckets. 1. Edits to his sworn statement testimony, including on the jail call, the dispatch call, and the discovery to the key at the Hallbox vehicle. jail call. They're referring to the 1994-1995 dispatch call would be the plates and discovery of the key to Hallbox vehicle. Statements identified in his cross motion papers, a hodgepodge of various visual and musical elements included in MAM, and facts about Avery, not Colborn, omitted from MAM. Colborn cannot show material falsity and deposition of his testimony. Reports on court proceedings are protected by the fair report privilege, and Colborn's argument that privilege inacceptable and not credible, as it is based entirely on the obscure treatise of the section of American jurisprudence. Does not Wisconsin law. Later, the Wisconsin Supreme Court opinion. Colborn ignores the Seventh Circuit's recent discussion of Wisconsin privilege, in which it is held that the privilege shielded to a news report that, like MAM, presented allegations made to the court proceedings, allegations provided, and plaintiff's own views, thoughts. The privilege is lost only if the reporting is non-substantially accurate. Netflix has already explained that the challenge edits are not accidentally false because they do not materially change the gist of the testimony. And Colborn appears to agree that Mason's Supreme Court's seminal opinion on altered quotations controls key to the holding of principle that statements of materially false for purpose of defamation claim only if would have different effect on the mind and read for the pleaded or the produced. Yada yada yada. One federal law in Colborn's argument is that rather than attempt to meet his burden to show the editing of testimony rendered the material false, he argues that the edits were selective and made him appear less credible. Colborn does not explain how this equates to a materially falsity, nor could he. Fairness and falsity in different things are credible and subject evaluation, not an objectively variable fact. Similarly, Colborn's unsupported insinuation that documentaries are required to provide disclaimers that the footage that presented have been edited. Viewers of a documentary understand that out of necessity, its footage has been edited. Certainly, viewers of MAM understood this. Of course we did. There was a 5-week trial that they squeezed into a few episodes. So, yeah. Colborn cannot show material falsity of 52 statements that appropriately support his implied libel claim. Colborn's discussion of purported flat-out accusations of framing is remarkable in that it does not bother to identify even one, instead of referencing Colborn's own cross motion for summary judgment. 52 statements emerged there, not actionable. Likewise, Netflix has explained why Mr. Colborn is wrong in his belief that 52 statements somehow imply that he participated in a conspiracy to plant evidence and lied about this testimony. First, Colborn relies on the republication doctrine is misguided, and not just because he fails to identify a single statement that constitutes a flat-out accusation of framing. Only one of the cases he cites in the doctrine involved mass media publications. The obsolete and 121-year-old Sands v. Doris, Wisconsin 663726, 1861. They cited the case from 1861. Wow. And most involved in the reputation emerged rumors. The case, meanwhile, involves a documentary about an important trial and the surrounding public controversy, which were both the subject of contemporaneous news reports. Colborn ignores both the MAM and documented public controversy, including many statements supporting him and contradicting any claims of framing. And the Seventh Circuit has made clear that the media reports depicting allegations as allegations and including the plaintiff's side of the non-actionable is false. Colborn does not mention financial federations and attempts to distinguish global relief primarily by arguing it was about government investigation. So is this case a murder trial is nothing if not an accumulation of very high stakes government investigation? Second, even if the court were to accept Colborn's allegations about the MAM implies as face value, Colborn must show a jury issue exists of the question of material falsity. Yet, Colborn does not point to any evidence in the record that would show any of the allegedly defamatory statements and implications that MAM is false. For example, although Colborn says the primary thesis MAM that he was a central figure in the law enforcement conspiracy to plant evidence, opponent at 33 does not deny planting evidence in this declaration. Instead, he refers to his trial testimony, which both complaining that MAM did not include enough of it at 53 and insisting erroneously that at trial, Avery's attorneys conspicuously avoided statements that made positive accusations of plaintiff evidence, joining response at 44. This failure precludes Colborn from meeting his burden on falsity and dooms his claims dismissal. Third, Colborn stays from the facts in his law and has falsely asserts that his statements cannot be substantially true in a matter of law and that they impute fundamental or criminal intent to a person who has been convicted or even charged with a crime, citing a Texas opinion that does not say that. Colborn then makes an even more absurd contention that statements describing a convicted criminal cannot be substantially true, where they convey that a convict actually committed the acts of which he was convicted. If Colborn's distortion of the law were true, he could be liable for defaming Avery by saying Avery killed Teresa Halbach. Very true. The law does not scrutinize contains such a ridiculous result. Colborn also complains about, for example, depiction of the physical reactions and the alleged use of graphics and other enhancements that purportedly point fingers at him. But none of this, even if properly pleaded in the SAC, and much of it was not, see paragraph 10, amounts of the material falsification. For example, it would not make any difference in the mind of a reasonable viewer whether Colborn is showing him making eye contact rather than looking down, or getting up from the witness stand rather than cracking his knuckles, or whether footage from the square format videotape was shown in full screen. Colborn complains that they especially identify him as alleged conspirators. In fact, he was one. Of the alleged conspirators, presided judge allowed to be named. Netflix addresses these claims in opposition to Colborn motion for partial summary judgment. Finally, memorize. Colborn has no basis for alleging Netflix directed that bad guy or villain music would play while he was shown. Regardless, music is not true or false or cannot redeem or render a documentary actionable. Defendant Netflix motion for summary judgment. Colborn must come forward with evidence that the statements, scenes, and alleged implications and challenges are false. Because he has not done so, Netflix entitled to summary judgment on the ground that MAM is substantially true. As Netflix demonstrated, Colborn's IIED claims fails with the defamation claim Colborn cannot prove. For the torch elements, Colborn's opposition does not change, for he implicitly admits Netflix did not distribute MAM to purpose of causing him emotional distress when he asserts Netflix instead had a compelling profit motive. He likewise fails to cite evidence that would meet his burden to show emotional distress was extreme disabling, and MAM was a substantial cause of alleged distress rather than the other stressors in his life or deranged third parties' statements about the documentary he never actually watched. I like the way they put that. For all the foregoing reasons, and for all the reasons set forth in the memorandum in support of the motion for summary judgment, Netflix respectfully requests that this court grant Netflix summary judgment to enter an order dismissing all claims against their prejudice. So, we have Colborn's team requesting a summary judgment, but that document has now been restricted. Let me see something real quick. Yeah, that was the blood moon I took. Let's see. Sorry. Let's see. 920, 426. That's strange. Let's see. Give me a minute, folks. Is it this one? Oh, it's not that one. I think this might be it. No, that's not it. I must have saved it somewhere else on my computer. I'll have to look. But I was reading through his motion for summary judgment, and what he cites is stupid. Okay, so that was that one. Now we got all the unpublished decisions that Colborn has cited to help boost his false claims. So here we go. A declaration by Baker. 2 pages. Cost me 20 cents. Okay. Understanding by filing sworn in other ways. I'm licensing private detective contracted with the law firm of Conway, Ipswich, Jerry. In addition to other items, plaintiff, producer, and discovery, the following: Colborn document number, hearing transcript, 19 pages, deposition of Colborn, and October 13th of 2005. Evidence, 19 pages. Calumet County Sheriff's Department, assist in missing person case. Facts on subpoena for Avery trial. Subpoena for Avery trial. Subpoena for Avery trial. Letter to Link. Josh Colborn. Conference with DA. Subpoena dated 1/11/07. I don't know how many of you guys know this, but the prosecution had a mock trial before Stephen Avery's real trial. Red flag. Facts to Remaker, evidence collection, letter to Rob Herman from Pagel, Manitowoc County time report, overtime documentation for 11/5/05, recognition report, subpoena, Manitowoc County Sheriff's Department summary, harassment voicemails, Colborn deposition testimony, and a narrative for dispatch. Some of these things we have, some of these things we do not, and I don't think we'll ever get to see them. Alright, let's see. Now we got declaration of Devil Bursick. Support of all plaintiffs. Motion. Let's read this one. Alright, 16 pages. Introduction. Plaintiff moved for partial summary judgment with respect to several issues concerning defendant's replication of defamatory third-party statements as part of the making a murder, broadcasting, including publication, defamatory meaning, actual malice, falsity. Further explained below, defendant's response to fail to proffer any legitimate reason to deny the motion under unique circumstances presented in the case. Argument: defendants do not dispute publication. Defendant's response do not appear to mention nor contest the publication of MAM. The third-party allegations repeated in MAM are defamatory. Netflix and Chrome each argue that there's nothing defamatory about the statements that are contained in MAM and identified as plaintiff's motion for a partial summary judgment. Defendants largely rely on the tact of considering each statement in isolation and out of context. As plaintiffs have explained on numerous occasions, Wisconsin law requires that a broadcast be considered in its entirety for purpose of defamation claim. And citing a case, the statements are identified by the time of broadcast. Mr. Colborn's initial brief to assist the court in locating the statements in MAM. They are presented together in the chart because collectively from a narrative that runs through the broadcast. Let me download this real quick. Broadcast which accuses Mr. Colborn of planting evidence. Contrary to the defendant's arguments, it does not take sophisticated linguistic analysis to discern requesting accusations from statements. In fact, it is directly stated on more and more occasions to the extent the defendants contend that it is difficult to understand the accusation from the third-party statements identified to him in Mr. Colborn's initial brief. Plaintiff provides following simplified synopsis. The statements identified in episodes 1 and 2, approximately 6 pp. 6a, and most of the page 9 of Mr. Colborn's opening brief, document 285. So go down here to 285, which was quite a long time ago, which is brief in support filed by Andrew Colborn, motion to plaintiff summary. That's when he filed for the first summary judgment. They've done it numerous times. It's just been going back and forth. Collectively set up the viewers the notation that Mr. Colborn is someone who had axed grind against Stephen Avery because Mr. Colborn allegedly misled a call to Manitowoc County. No, the only person that had axed the grind was Dennis Vogel and Tom Kucerk. And that's why Tom Kucerk tried to get out of his deposition and eventually ended up happening because they arrested Stephen Avery for a gun charge. Therefore, he wasn't able to attend the final 2 depositions. And then his attorney, don't know why, convinced him to settle and take the settlement and drop his $36 million to take $400,000 to use for his defense. Why not just continue your lawsuit? Glenn knew he was going to win, so I don't see why he just didn't foot the bail that they were asking. I don't know. It's political now, and there's so many people involved. It's sad. That's an understatement. Next 3 sets of statements included identified pool hall patrons confirming that Mr. Avery was framed by the Manitowoc County Sheriff's Department for Miss Hallbach's murder. The next statement includes Avery's statement to his sister. They figured they just got away with it, and obviously reference to the civil suit settlement for the prior wrongful conviction. They can do it again. In the next 2 statements, Avery's new criminal defense attorneys, Dean Strang and Jerry Bruning, first mused about officers' alleged motivation to plant evidence and directly accused them of doing so. They thought, we're going to make sure he's convicted, and they helped it along by planting his blood in the RAV4 and planting that key in his bedroom. These are out-of-court statements that appear to be made in interviews. In the next 4 statements, Buting continues discussing the framing allegations, then asserts that the sheriff has a strong dislike for Avery. And Sheriff Peterson went on Dr. Phil and even said, well, look at Gene Couche's deposition. He was questioning where the evidence came that exonerated him. Funny how we're now questioning how the evidence was obtained to convict him. In the next 4 statements, Buting continues discussing framing allegations and asserts that sheriff has a strong dislike for Avery, and therefore that too would permeate over Exilian and the department, including the lieutenants and the sergeants at the point Mr. Colborn and James Link. Photographs are shown as suddenly eliminated compared to other photographs in the subsequent department photo. High receipt, document 285, page 11, after the sequence revealing supposed tampering with vial of Avery's blood that had been stored in the courthouse, Buting says. Some officer went into the file, opened it up, took a sample of Stephen Avery's blood, and planted it in the RAV4. Again, this is an out-of-court statement. The defense arguments of the jury at the Avery criminal trial tried to step such direct accusations, as the defense argument was the reasonable doubt as to whether officers could have planted evidence should have compelled. The thing is, though, a lot of these officers gave statements to the Netflix producers. They just never signed off on it. So, in the next three statements, first, Buting states, again, out of court, somebody knew that Miss Hallbach's vehicle was there before they even went there. I'm convinced of it. A brief segment of apparent interrogation of Avery follows, in which he tells the interrogator that he has told that put Miss Hallbach's vehicle on his property and planted evidence. Emphasis added. MEM next cuts to the footage of Mr. Colborn about to testify, and the conclusion of the same episode. Mr. Colborn edited testimony appears to show him admitting his call to dispatch made it sound as though he was looking at Miss Hallbach's vehicle when he made the call. In the next identified statements, Buting explains how, again, out of court, that only two or possible one officer would have had it and inspired to plant evidence, concluding, who better than an officer would know to frame somebody? Well, let's just take this into consideration. Mark Wiegert contacts the Manitowoc Sheriff's Department looking for assistance, looking for a detective. Dispatcher says, no detectives around, but I can attach you to my shift commander, which just happens to be Andrew Colborn. Then we have audio of Dave Remaker being paged and Dennis Jacobs being paged by James Link. So who do you think contacted James Link? My guess is as soon as Colborn hung up that phone, he called Link and said, hey, we got a missing girl in Calumet, and she was at the Avery property. So, and Colborn claims to have been there interviewing him at his mom's house when he was walking in the door of Menards. I mean, come on now. And the fact that Colborn doesn't even write a report about even talking to Stephen Avery until he's instructed to 8 months later when Manitowoc does their summary report. Okay, next identification statements include exchange between Buting and Strang, in which they appear to discuss alleged planting of the key, Miss Hallbach's key, in Avery's room, including that Buting stating that the bottom line is that they knew their boss had just recused the department and turned over lead authority in the investigation because of the lawsuit. It's even stated there in the case report. Greg Shetter recommends to Jerry Pagel that they should take over the case because of the lawsuit with Stephen Avery and the Sheriff's Department. So that's why they transferred to Calumet. Because technically, it's Manitowoc's jurisdiction. Statements obviously refer to Mr. Colborn and Mr. Link, members of the Sheriff's Department, who had both been deposed in the Avery civil suits weeks before Teresa Hallbach disappeared, and who were both in the room at the time that the key was discovered. True. And another thing about that key, we have Stephen Avery's toothbrush being found by Jody underneath the sink. How to get there? Stephen didn't know. I have an idea. Seems like they rubbed his toothbrush on that key and then dropped it. Or vice versa. Either way, that DNA from Stephen Avery did not come from him touching the key. Reference to dispels doubt and immediately juxtaposing an image of Mr. Colborn as Avery continues speaking, then juxtaposes Images of Colborn waiting to testify and Avery looking sad. And the next identified statement in question by a reporter of Tudine Strang speaking out of court concludes that Strang shows asserting that the evidence against Mr. Colborn, who was directly referenced in the reporter's question, is stronger than evidence that has been used to prove conspiracies in federal court. Later in the same episode. Well, let me get back to that. I didn't even get to my point. So Colborn's contacted by Calumet. He then contacts Link, I'm sure. Link asks them to Page, Remaker, and Jacobs to come in. Then Don Jeterine is dispatched over to Manitowoc from Calumet because George Zipperer, who they talked to on the phone, says, "Talk to my lawyer." The dispatcher, when he's relaying this information to another officer, he states that yes, John Dieterine is on his way over to the Zipperer's residence because apparently she'd been to 2 locations in Manitowoc, one being her friend, Stephen Avery. Yes, he says Teresa and Stephen were friends. So this dispatcher is obviously getting his information from 3 sources. It'd be Jerry Pagel, Mark Wiegert, or John Dieterine. But when Mark Wiegert calls and asks for John Dieterine, after he radios in and says, "I'm leaving for Manitowoc," he's got his radio turned off and not answering his phone. Wiegert calls and asks, "Do they know where John is?" And he says, "Oh yeah, he's standing right next to me right now." That's what Jerry Pagel says. So why does John Dieterine tell the dispatcher that he's en route to Manitowoc when he clearly is not? And just the whole timeline of them arriving there, and we obviously know that everybody was contacted by phone first, except for Stephen Avery. I mean, we got Sipple calling just after, right before 6 o'clock, because he was selling the car along with her first appointment. So, no, there's lots of things that have tied together that I just don't talk about. There can be no reasonable argument that education, an intelligent person, such as a representative of Netflix or Chrome Media who produced MAM, could possibly have failed to appreciate the collective impact of accusations by Avery, his family members, and attorneys that Manitowoc County Sheriff's Department officers planted evidence to frame for Miss Hallback's murder, and the fact they did, document 330, page 50 through 51. MAM emphasized at every turn that these accusations pertained by Mr. Colborn, as noted above, through a justification of the videos and other gimmicks designed to draw attention to Mr. Colborn while they were repeated. Also, contrary to the defendant's arguments, these accusations are never genuinely disputed by anything in the MAM. Rather, the statements made by the law enforcement and prosecution characters in MAM were included to let them have their day as a prelude in retelling their perspectives of our more reliable narrators. Further, supposedly, including a cautionary statement, does not insulate the publisher from liability of the defamatory statement or the unmistakable theme of the production of the contrary. The rule is only common sense, otherwise every person could defame anyone else with impunity through the simple artifice of tagging or purification. But he denies it after accusations of all manner of reprehensible conduct. Indeed, MAM and denials were altered by deliberately misrepresent the manner of Mr. Colborn's testimony. So denials of defendant's claims exonerate the additional falsehoods. Having weaponized Mr. Colborn's own statements against him, defendant cannot credibly claim that the statements soften the blow of the third party's direct accusations, but to extent the statements may be construed and ambiguous as to whether they are defamatory or Mr. Colborn in question of fact were presented for the jury. Defendants wrongly characterized Global Relief Foundation versus New York Times as a controlling authority. Defendants have acknowledged in other submissions in the diversity case, the court appeals to the law of the state in which it seats, which means that Wisconsin law controls. Wisconsin is in defense, and the substantial truth can excuse inaccuracies of expression and defamatory charges. True in substance, However, the false statement that a person had been charged with or committed a crime was not a slight inaccuracy. The defense of substantial truth does not sanitize glaring falsehoods, even presented as a series of true or substantially true statements. Further, as plaintiff explained in the prior to the submissions, the global relief concerning reporting about a party that had been investigated by government agency misconduct. In contrast, here, defendants made direct accusations against the plaintiff and others that were leveled in a government actor but convicted murderer who's attempting to cast doubt on his guilt. Moreover, the defendant Avery did not even testify at his trial, yet many of his direct accusations are included in MAM. The defendant's broadcast had more sting than Avery trial and evidence the reaction Mr. Colborn encountered after MAM, on which defendants also heavily rely. The courts considered a newspaper defendant's reporting about a financial advisor who was sued for mishandling funds. The newspaper reporting about allegations against him and ultimately holding of the court that engaged in bad faith were reported, and the defendants bolstered and magnified the theories that a convicted murderer's counsel suggested could provide reasonable doubt, and though statements that were never made in court were exposed, video imagery made them into express and implied factual accusations were published after the criminal convicted and directly accused Mr. Colborn planted evidence to ensure this conviction. The facts of the case are worlds apart from there is not considered global relief. Nor is this case about interpretation of the ambiguous source materials. Chrome argues defendants deliberately enhanced the published express accusation of criminal conduct based on the word of convicted murder. An irrational interpretation authorized false accusations, criminal conduct would swallow defamation law whole. Defendants' actual malice can be determined as a matter of law. Defendants argue that the alleged subject intent cannot be determined on summary judgment as a matter of law. Plaintiffs agree that the many of the not. This is pretty boring to be reading. I'll be honest. This is just them stating all kinds of case laws, like the previous filings, which are this one. Yeah, they're just all the cases that they cited. It's not plausible the accusation were published in ignorance. Below is a link to the story produced by Discovery. Crime Story, 12 Days of Crime Story Day. More demos, Laura Carter making a murder. Defendants admit that Mr. Colborn testified to the falsity of planting evidence, accusations, and they can produce no evidence in response. But, nothing really new. Just them going back and forth. Now, Colborn wants it to go to trial. Y'all got any questions? Alrighty then. But hopefully we get these documents filed by Kathleen Zellner. My question is though, is she going to be adding something to her trial or her motion, or rewording it, taking something away? I don't know. But y'all have a good night. See y'all next time.